皆さんおはようございます。ブラッドです。今日のトピックはもしもシリーズの Inventor Problems。Hello and welcome back to another video. Today we're going to talk about what-if situations and specifically inventor problems. So 37 CFR 1.63 is the rule for the inventor's oath or declaration, and in general, the inventor or each individual who is a joint inventor of a claimed invention, so each individual means every joint inventor of a claimed invention, in an application for patent must execute an oath or declaration directed to the application except as provided for in 1.64. So this means that the inventor or every joint inventor must execute an oath or declaration. Oath or declaration is just giving some information, signing a document, and then you have to kind of swear that the information is true. So what if we have some inventor problems? What can we do? Well, first of all, let's go over some of the problems. So for example, what if the inventor dies? The inventor could die before filing the application or during prosecution after filing. The inventor could be legally incapacitated. This means that they could have a problem with their brain or something like that, and then they can't make decisions or they go crazy. That's another thing as well. Or maybe the inventor's unavailable. The inventor maybe leaves the company. The inventor doesn't want to talk to you anymore. The inventor runs away. Who knows? These things happen sometimes. So instead of the oath or declaration, we need a substitute. We have to substitute something for that oath or declaration. And this is 37 CFR 1.64, which is substitute statement in lieu of, just means replacing an oath or declaration. So we have instead of an oath or declaration, because we can't do that, we will file something called a substitute statement, which will take the place of the oath or declaration. Here's the rule. So an applicant under 1.43, 1.45, or 1.46, these are three different types of applicants, and I'm going to go over those in a minute. These applicants may execute a substitute statement in lieu of an oath or declaration under 1.63. So 1.63 is the oath or declaration rule, but instead of that, we can do a substitute statement. So if the inventor is, and basically these kind of four situations, inventor is deceased, dead, is under a legal incapacity, which means some kind of mental problem, has refused to execute the oath or declaration, so they're hostile, they're not cooperating with you. Maybe they went to a competitor, they're a competitor's company, or they cannot be found or reached after diligent effort. So you searched for them, but you can't find them. So we need a substitute statement if, just to summarize, if the inventor died before or after the filing, the inventor is legally incapacitated, so there's a mental problem. The inventor is unavailable. Unavailable basically means refuses to sign the oath or cannot be found after a search. Who can file the substitute statement? Well, the rule 1.64 says an applicant under rules 1.43, 1.45, or 1.46. And those applicants are, under 1.43, a representative of the dead inventor. So this means the inventor died, and then there is some other person that is handling the inventor's possessions and things. And the interesting thing about this is this representative, if you're in Japan, if you're a Japanese inventor, the representative will be decided by Japanese law. So that's 1.43. 1.45, another joint inventor. So if you have, let's imagine you have three joint inventors, and two of them sign the oath or declaration, but the third joint inventor says, I'm not going to sign anything. Well, if the other joint inventors, those other two, they can file the substitute statement in lieu of the third inventor's oath or declaration. And then an assignee. under 1.46. So I put assignee in quotes because there's basically three different conditions. There's one condition where there is an assignment. There's another condition where the inventor has an obligation or a duty to assign to the assignee, which is usually the company. And the third situation is there's no assignment at all. So this would be under CFR 1.46. So these are the three different applicant types who can file a substitute statement, and they don't need an oath or declaration to file a patent application. Death or incapacity. Under 37 CFR 1.43, an application for patent by a legal representative, this is the person appointed if it's a Japanese inventor that's died, under the Japanese law. They will appoint a legal representative. So a legal representative of a deceased or legally incapacitated inventor. And then the rule here is if an inventor is deceased or under a legal incapacity, dead, or has some mental problem, the legal representative that is appointed for a Japanese inventor under Japanese law, that legal representative, which is a different person, may make an application for the patent on behalf of the inventor. If an inventor dies during the time intervening between the filing and the granting of a patent, which is basically during the prosecution time, if that happens, the letter's patent may be issued to the legal representative, so they'll receive the letter's patent upon proper intervention. What does CFR 1.43 mean briefly mean? So your inventor dies or is legally incapacitated. You're looking at this rule. And the legal representative that is appointed under Japan law, if it's a Japanese inventor, this legal representative can do two things. They can file an application and they can receive the letter's patent under this rule. So next, we have joint inventors. This is the second type of applicant who can file a substitute statement under 1.64. So joint inventors is under CFR 1.45, and that's an application for patent by joint inventors. And so if a joint inventor refuses to join in an application for patent or cannot be found or reached after diligent effort. So basically the joint inventor says, I'm not signing an oath or declaration with you guys. Or you can't find this other joint inventor and you searched for the joint inventor. So cannot be found or reached after diligent effort. The other joint inventor or inventors may make the application for patent on behalf of themselves and the omitted inventor. So this means those other joint inventors that have submitted the oath or declaration, they will also submit a substitute statement under 1.64 in lieu of the missing inventor's oath or declaration. The summary of the rule, CFR 1.45, there's a joint inventor that refuses to join, or the joint inventor, one of them cannot be found after you searched for them, you couldn't find them. And then the joint inventors who remain, they can file the substitute statement under 1.64. Okay, so moving on to the last type of applicant, it's an assignee. And an assignee is handled under CFR 1.46, an application for patent by an assignee. So one type. So an assignee means there has been an assignment from the inventor to a company, for example. Obligated assignee, which means there's no assignment yet, but the inventor has a duty to assign. Usually it's under a contract or something else. Or a person who otherwise shows sufficient proprietary interest in the matter. So that third category is there has been no assignment and there is no duty for the inventor to assign. There's no obligation, but that person, they show the patent office that I have a real interest in this invention and I need permission to file this substitute statement. So the rule here is under 1.46a, a person to whom the inventor has assigned or is under an obligation to assign may make an application for patent. A person who otherwise shows sufficient proprietary interest in the matter may make an application for a patent on behalf of and as an agent for the inventor on proof of the pertinent facts and a showing that such action is appropriate to preserve the rights of the parties. So it's a little bit higher standard, and that makes sense because a person that does not have an assignment and there's no obligation to assign, you have to prove, you have to argue to the patent office, I should be allowed to file this substitute statement because I have an interest, and if I cannot file this substitute statement, the interest would be damaged. Mine or other people's interest in the patent would be damaged. They could lose patent rights, for example. Okay, so let's break down that rule. CFR 1.46. So you have an assignment. So let's imagine you're a Japanese company. Your inventor has assigned the invention to you, so you have an assignment. So you're an assignee. Or the inventor didn't assign yet, but there is an agreement where the inventor will assign to you. The inventor promised to assign to you. That's the second type, obligation to assign. And then third one is no assignment. But if you can show the sufficient proprietary interest as described in the rule, it could be okay. You could file a statement. All right, so here we go with the bonus English lesson here. I want to go over this word substitute and also in lieu of, because in lieu of is one of the words from the rule, and I think it's kind of similar to substitute. But this is the usage for substitute basically. Here's an example, and this refers to 37 CFR 1.64. So this is just an example sentence. We substituted the 1.64 statement for the oath. So we substituted the 1.64 statement for the oath. That means we didn't use the oath and we used the 1.64 statement instead of the oath. Another way is to use with instead of for. So that reverses the words. So you put the old one first, the oath. So we say we substituted the oath with the 1.64 statement. The meanings of both of these sentences is exactly the same. There's just two ways to say it. And I think it's basically personal preference. So you can use either one, whichever one you like. And to go back over that, so this is how it goes. This is kind of the pattern. We substituted the new thing, which is the 1.64 statement, I'm using the colors there, for the old thing. New thing for the old thing. The new thing replaces the old thing. Or you can say we substituted the old thing with the new thing. In both cases, you are replacing the old thing with the new thing. So it's like when you file the substitute statement under 1.64 for the oath. You're not filing the oath, you're filing the statement. So here we go, let's do it in lieu of. So in lieu of is a little different because we are using a verb here. So this is the pattern. So we verb the new thing in lieu of the old thing. So the new thing replaces the old thing. And as an example, we filed the 1.64 statement in lieu of the oath. One point about the term in lieu of, it's usually written. Or it's more proper. It's not. We usually don't say in lieu of to our friends or coworkers. We'll usually say substitute. And but when you read these rules, I think especially in the MPEP, you'll see in lieu of quite a bit. So I think it's important to know it for reading and writing purposes, but for speaking purposes, substitute is really what we use the most. All right, well, thank you very much for watching, and I look forward to seeing you in the next video. ありがとうございました。